Morning, and thank you for joining us for BVI Finance's Breakfast Forum. I am Elise Donovan for BVI Finance. In today's Breakfast Forum, we talk about the BVI's preparation for the fourth round CFATF mutual evaluation of the Virgin Islands. This is part of the process of the Financial Action Task Force's evaluation. The Financial Action Task Force is the international body that sets the standards or recommendations for combating money laundering, terrorist financing, and proliferation financing. Our experts today are none other than the Managing Director and CEO of the BVI Financial Services Commission, Mr. Kenneth Baker. Also joining us is the Deputy Managing Director, Regulation, also at the Financial Services Commission, Mr. Glenford Malone. Kenneth Baker was appointed the second Managing Director and Chief Executive Officer of the Financial Services Commission in February 2021. As the Managing Director CEO, he is responsible for the administration and operation of the Financial Services Commission. His responsibilities include regulating the BVI's financial services industry, the development of new service and product offerings aimed at developing and enhancing the attractiveness of the BVI as a situs for legitimate cross-border financial services, and liaising with government and private sector stakeholders in pursuance of this objective. Mr. Baker has a track record of 37 years in the banking and financial services sector. He joined the Financial Services Department in 2000 as the Inspector of Banks and Trust Companies after a private sector career in banking. He was appointed the Deputy Managing Director Regulation in April 2005, and he jointly held the position of Director Banking, Insolvency, Fiduciary Services Division, and he has professional qualifications as a business administration in international corporate finance, a Bachelor of Business Administration in international corporate finance. Also, today's other expert is Mr. Glenford Malone, and he was appointed the Deputy Managing Director for Regulation in January of 2022 and is responsible for implementing the Commission's overall regulatory strategy. Mr. Malone has over 2 decades of experience within the regulatory environment, having served many roles such as Senior Regulator, Deputy Director, and Director for Investment Business, and prior to 2002, Assistant Registrar for Mutual Funds with the former Financial Services Department. Now the Financial Services Commission. Mr. Malone is a certified anti-money laundering specialist and is a trained financial examiner in the FATF methodology of assessing compliance with the Financial Action Task Force's 40 recommendations. He has a Master of Laws with distinction in law and finance, and he also has a Bachelor of Business Administration, Economics, and International Business. I would like to welcome both Mr. Baker and Mr. Malone for joining us for today's session, where we talk about the CFATF mutual evaluation. Over the last few years, we have been going through this process, and we know that as part of this evaluation, the assessors for the International Monetary Fund, the IMF, and the CFATF will be in the BVI from March 13th to the 31st. I will ask Mr. Baker to introduce what we're going to talk about, and then we'll ask Mr. Malone to answer some of these questions. Mr. Baker?
Thanks, Elise, very much, and thanks for having us on this breakfast forum. Now, the BVI is one of the founding members of CFATF, And as part of that membership comes the obligation to be assessed on a periodic basis. This is the fourth round of the assessment, the last one being in 2008, when we got what we describe as a very, very good outcome. Since then, however, the methodology has moved on and is now encompassed two essential elements, which is the technical compliance, which is to say whether or not you have the legal framework in place to prevent money laundering. And the second component, being more rigorous, is the effectiveness component, which is to say how well have you implemented the legislative framework. And so was the last time it was mainly around the legislative framework. This time around, it is more how well have you implemented that, and can you demonstrate an effective regime. So this is a fourth round of evaluation. And there's a handful of assessors will come and will participate in that process, although it has been, the process started since last year. But Glenford will go into more details as to what are the elements of that assessment.
Yeah. Excuse me. Good morning. You hearing me, Elise?
Yes.
Okay. Yes, as Mr. Baker said, I'll go a bit into details. He said a handful of assessors, but it's actually 10 of them. I'm not sure 10 is a handful. It's usually 6, but it's actually 10 of them, given the nature and the size and the type of jurisdiction the BVI is. Primarily, we have 2 separate sectors, the domestic sector and the international finance sector. Hence, usually when you have that, they have two a significant different type of team. Was the assessment officially started sometime in June last year? Technically, the assessment started from 2017 because we were supposed to be assessed in 2017, and we all know the issues around 2017. And coming forward, we were supposed to be assessed sometime in 2020 as well. We all know what happened in 2020 as well. So we're now at the point where things have settled down to a point where we're able to be fully assessed. As Elise mentioned, the on-site is while the team is going to be on the ground from the 13th, it actually starts on the 15th, ends at the 31st. What that means is from the 15th, the assessment team is going to be on the ground interviewing various parties in the jurisdiction. What they're going to start out with is interviewing the public sector. So the public sector here means the FSC, Attorney General Chambers, Royal Virgin Islands Police Force, Office of the Director of Public Prosecution, Governor's Office, Financial Investigation Agency, Airport Authority, Port Authority, His Majesty's Customs, Virgin Islands Shipping Registry, and International Tax Authority. So now that you heard all of those names, this assessment has a very minor component dealing with the FSC. It is a jurisdictional assessment. So they're going to be looking at just about everything. They're also going to be interviewing the private sector, meaning financial institutions, DNFBPs, MPOs. We've already contacted in conjunction with the FIA. We've already contacted relevant FIs, DNFBPs, MPOs, and agreed who would be interviewed. And that has been agreed with the assessment team as well. So there's a number of people who have already agreed to be interviewed. We had what we term a sensitization session with those persons last week. So I've given them an idea of what to expect, what the interviews would be like, what kind of questions the assessment teams are likely to ask. Again, these interviews are not necessarily an interview or they're not an inspection of the relevant company. It's just asking, for example, how do you do CDD, etc. But we have two pools of people, those who have been selected for interviews, and we have a pool of those who are agreed to be selected. Sort of like a pool that we can draw from what the assessment team does. And this is customarily in every assessment. They have, at the end of the assessments, 2 free days. We call them free days, but they're working days for them, where if they need to interview additional persons, additional companies, they would use that time and they would ask us for relevant persons. So what we did is we created a pool. So everyone would be familiar with, everyone would understand. If they're drawn from the pool, they would know and be prepared. So we have that pool in the event that the assessment team asks to interview additional people. That happens sometimes. It depends if, for example, they start to speak to certain sectors and they're getting variant responses and they want to confirm, they might ask to speak to more people within those sectors. We've also been working over the course of the last, I would say, 2 to 3 years, sensitizing the public sector and working with the public sector agencies on what is expected. And I think I should have mentioned from the beginning that it was agreed and approved that the commission would be the lead agency on this assessment, leading the preparation. And the commission internally have a mutual evaluation prep team, which encompasses persons as well from the FIA and the Attorney General chambers. Over the course of the past year, we've been in constant engagement with the assessment team, going through what we call the technical compliance annex. That's us saying, here's the laws, here's how we comply. And the assessment team coming back and saying, yay or nay. These are some of the issues that we think you haven't fully addressed, or asking for additional information. And most of you would be aware, if you listen to the House of Assembly last week and saw the Gazette come out last week as well, there are various pieces of legislation which are being put to the House of Assembly for approval. Most of those are to address some issues that the assessment team have identified, some of which, frankly speaking, we don't necessarily agree with, but you don't wait until the plenary floor when the assessment team has the benefit of the doubt to argue. We can change them now. So we're changing them now and putting them beyond reproach. So you would see amendments to the BVI Business Companies Act. The most consequential amendment there is the one in relation to beneficial ownership of a company, requiring the company itself to maintain beneficial ownership and provide that information to the agent. That is a requirement of Recommendation 24. It was actually part of the amendments made by FATF, I think October last year or June. So we're making that amendment to be compliant. We think that in majority of cases, that information already rests with the company and the agent. It's just a matter of codifying in law that requirement. As is customarily, we did had various meetings with the Company Law Advisory Committee to deal with that. There's going to be some amendment to the Counterterrorism Act. Those are technical, to Drug Trafficking Act as well, to change and increase penalties. There's going to be some amendment to the Money Services, Financing and Money Services, Securities and Investment Business Act, Company Management Act, and Banks and Trust Companies Act. Significantly, all of them are going to create and change the definition of significant interest to make them consistent across the board with all regulatory sectors. There was a number of inconsistencies in relation to control, and we're correcting that in all of the legislation. Effectively, that definition is now going to look like the definition that is already in the AML legislation. In terms of company management, just to point out as well, we're changing the definition of company management to actually mirror the FATF glossary and to mirror what's in the AML regulation. The AML regulation has it correct. I think what we missed is where someone was arranging for someone else to act as a trustee or making an arrangement for someone else to act in different capacity that was not in the Company Management Act. So we're making those changes. There's going to be some other changes to the Proceeds of Criminal Conduct Act. There's going to be an amendment to the Limited Partnership Act to make the retention period 5 years. And there's going to be an amendment to the Partnership Act. This is a substantive amendment to bring back in, I think it's Part 6, which was incorrectly deleted at the point of when the Partnership Act was redone and brought into force. And what that did is there were certain things in there that made it that partnership didn't have to comply with a number of the requirements that they ought to comply with. As well, you would have seen the amendments to the AML regulations, which have already been gazetted and now in force. And there's going to be some other consequential amendment to the AML code, which should come into force in a few. Finally, Elise, I think I'll just mention that when the assessment team looks at a jurisdiction, they create what they call a scoping note. A scoping note is effectively saying, here is the risk and context that we see in the jurisdiction, and here are the issues that we would focus on when we come on site. So in relation to this audience, they're going to be focusing on the way TCSPs, banks, real estate agents, lawyers and accountants in their capacity of what you would call professional facilitators, how they implement the AML CFT regime and how the supervisors, both the FSC and the FIA, appropriately supervise those agencies, those institutions. As well, they're going to look at the issue the issue of the day, I would say, this issue of corruption, domestic corruption. They're going to be looking at that issue from a perspective of whether or not all our institutions have implemented capacity to protect themselves against those. And as well, they'll be looking at virtual assets and virtual asset service provider, the new regime, and the inherent risk that has been quite evident with virtual assets and virtual asset service providers, and the fact that it's publicly out there that there is significant activity in that arena being carried out from within the BVI. And most of you would have seen we issued, the legislation was passed, it was brought into force, we issued some application guidelines, as well as we issued some guidelines for AML CFT, and these were specific to address issues that we know the assessment team would raise. So Elise, I know that probably a bit long-winded, but that's my introduction to where we are right now.
Well, that's quite a bit. And I think you have been working on this process for how many years?
I think Ken would tell you when I came to the commission, they introduced this to me in 2006. So I've been at this way too long.
Okay. You said, Ken, you said that, our last assessment was in 2008, and we were actually supposed to be assessed in 2017. But though we were supposed to be assessed in 2017, you're still passing all these legislation, doing all these, amendments and preparation. So were we in a position in 2017 to go through this evaluation process if it had actually taken place when it was scheduled to?
Well, at least I think, well, we were to an extent. And if you look at, how we develop legislation, it's really designed to ensure that we comply with the international standard, and in this case, the FATF recommendations. But then the assessment is started in an independent process where they review what we have done. And whilst we thought we had covered everything, clearly there are one or two areas where we didn't cover that. But even sometimes when you cover an area, the assessment team can have a different interpretation on your legislative framework, particularly when you have assessors who come from the civil jurisdiction, because they tend to understand the legal framework differently and apply their civil concept to it. And so sometimes you have where the assessment team comes up with a position that differs from you. And as Glenford rightly pointed out, there are times when you don't want to risk having to debate that on the plenary floor. And if you can address it ahead of that, then you stand a much better chance of being more fully compliant than you otherwise would. So it's a lot of the time it comes down to the interpretation of the legislative framework. So yes, certainly the intervening period gave us time to address other things that we didn't address, but even so, the methodology changes on a regular basis as well. And once it changes, then you're expected to comply with those changes almost immediately. As Glenford pointed out earlier, there was a change in October of last year. And once that change happens, then any subsequent assessment will look at that new methodology. And therefore, we then had to review the legislation and bring it up to date with those recent changes.
Okay, we're opening for people to put your questions in the Q&A. In the interim, you said we have 10 assessors come in. Some are from the International Monetary Fund and some are from the Caribbean Financial Action Task Force. Do you know which countries these assessors are coming from?
Yes, just to be clear, we have to, the process involved the jurisdiction agreeing the assessment team. And we long ago agreed the assessment team. You don't necessarily refuse an assessor based on where the assessor is from. It's usually based on their qualification. I could tell you the assessment team are highly qualified persons who have been involved in assessments before. Some of people, for example, I know this one individual is a former senior prosecutor. One individual is who's coming from TCI. He is the director of the FIU there. So we have significant experience and persons from various areas, all of whose CVs and stuff we had analyzed before agreeing to, and like any other jurisdiction would have done our own due diligence to ensure that they're equally capable and qualified to do the assessment. So yes, we know who they are, we have their bios, and they're highly qualified people in my view.
You yourself has been part of assessor or assessment teams. Any of the persons that you've worked with previously on this team, or is that allowed?
No, well, all I could say is that usually when you do one assessment, you don't pass back. It's usually so in-depth and so tiring for assessment teams that many people just do it once and move on. But I'm familiar with a number of the assessors. I'm familiar with about 3 or 4 of them. I'm very familiar with the lead assessment team. Ironically, one of them who was on the lead assessment, the IMF person, actually was involved with the BVI assessment in 1999, I think it was. That says more about where he is as opposed to the BVI, but Though we're quite familiar with members of the assessment team.
Okay.
If I could follow up on that comment that Glenford just made, because I think person might be interested to know, well, why is it this assessment is being led by the IMF in conjunction with CFATF? And the reality is that the IMF has had a long history of doing assessments around the world. And in fact, they performed an assessment of the BVI in 2010 in the offshore financial sector assessment. And so they do both the, and they do a number of assessments. They do the Article 4 assessment, which they do for member countries, but BVI is not a member country. So they did some OFC assessment many years ago. They don't do them anymore. And they also do the AML, CFT, assessment in conjunction with either the FATF or other FSRBs, and the CFATF is one of those FSRBs. So the IMF has had a long history of doing assessments, and they have some very, as I said, I Glenford pointed out, very highly capable and experienced persons, and it is those sort of institutions where the assessment team would be involved in multiple assessments. So as Glenford would point out, he did one something he doesn't want to pass back, but when you work for the IMF and the CFATF, especially if you work at the Secretariat, then you end up doing multiple assessments, and in fact, you sometimes may end up going back to a jurisdiction on two or more occasions.
Okay. You mentioned all the public sector agencies, the AG's office, the police, the DPP, the governor's office, the FIA, the ITA, which, are traditionally departments or offices that you would expect to be a part of this process. But you also mentioned airports, the Port Authority, and the Virgin Islands Shipping Registry. Now, I could be incorrect, but I don't think previously these were mainstream part of the assessment. And I think there are some I guess concerns that have arisen. How are we prepared, and where do we stand in terms of these non-traditional agencies that don't necessarily go into the AML, CFT processes?
Well, I think this is where this assessment, as Mr. Baker said, this assessment is so different from 2008. Whilst we don't think about them as traditional agencies for AML, they all are actually part of what we call an intergovernmental committee for AML CFT purposes. But just to talk about how they actually link to the process. So under the FATF standards, when you come into a country, you're supposed to hear that you're supposed to declare. When you're leaving a country, you're supposed to be able to be screened. So when that happens at the airport, that happens at the port. For example, if you look in the news, people might be arrested at the airport for failure to declare. Most of that actually starts with the screeners at the airport going through luggage, etc. So that's where the airport authority comes in. There's actually a significant amount of process between the airport authority, His Majesty's Customs, and the Royal Virgin Islands Police Force in relation to cash smuggling. And if you look at, I think it's recommendation 32 in relation to cash couriers, that's a specific recommendation which therefore directly involves the airport authority. Now, if you think about the port authority as well, the port authority is responsible for the seaports, which as well has passengers going and coming. And you still have the same issue of cash couriers, etc. You also have the issue of cargo at the port and the issue of smuggling, etc. So how does security, how does these deal with? If you also now think of Virgin Islands Shipping Registry, many of the persons on the call would be aware there is significant business through what BVI business companies registering vessels and registration of vessels through the Virgin Islands Shipping Registry. These vessels can operate just about anywhere. So there's a risk in relation to the operation of vessels. You look at our recently issued proliferation finance and risk assessment, which identified that issue. So there's also the issue surrounding shipping registry and how do we implement sanctions related to shipping and the like, including the Russian sanctions. How do we identify the beneficial ownership of all vessels? How are we able to provide information in relation to those vessels? What we have been doing as the mutual evaluation preparation team, we have been providing what we call guidance to each one of these agencies. We've had sit down one-on-one discussions with them, go over what needs to be done, what the issues are, and preparing them for what the assessment team would be asking. So while they look in some regards, you might think, oh, well, I don't see no connection of any of these agencies. They do have specific connections.
And they've been recently in the news over the last, year with all
Yes,
that has happened.
that goes without saying. They'll ask particular questions surrounding the institutional nature of how you prevent certain things.
Okay, we now have, a question. We had one question from the audience, but I'm going to defer that first one with regards to the EU non-cooperative jurisdiction list, because that is for tax purposes. This is for AML, CFT, proliferation financing purposes, which are two separate evaluation processes. But, if Mr. Malone feels so inclined, he can I guess make the distinction, but let's move on to the next question. In this round of review, to what extent will the assessment team take into account legislation not yet brought into force, considering that the focus seems to be more on effectiveness than technical compliance?
To be frank, when all these legislation, hopefully knocking on wood in my office, passes tomorrow, they will come into force sometime the following week, because they have to be enforced. Once legislation is enforced by the end of once it's enforced before the assessment team gets on the flight and the flight lifts off from Terrence B. Lettsam International, you would get credit for technical compliance. Again, many of these, frankly speaking, many of the amendments are really things on the effectiveness side we are already doing. It just have some little intricacies in relation to the technical compliance that we need to clean up. And the two tranches that they look at many times, after they don't look at the TC, then they concentrate on the effectiveness. Yes, if you have very limited TC compliance, it would impact on the effectiveness. But we've considered that we would have significant TC compliance, and in areas that we have minor deficiencies, we think these amendments would cover the significant portion of those.
Okay, please post your questions in the Q&A section. You mentioned that there's an amendment to the business companies which requires beneficial ownership to be kept with the company and provided to the registered agent. How is this different from the BOSS legislation?
The difference here, and I would not say I'm an expert on BOSS, which I am not. I think I'll stick to the AML legislation. The difference is, and under the AML legislation currently, the requirement is for the registered agent or the financial institution to update the information, to inquire based on his risk assessment. So every year for higher risk entities, at least 4 years for lower risk entities. But there's actually no requirement that a company who knows or should always know who their beneficial owner is to maintain that information. The standards, when it changed, said the company should maintain that information. So the company would maintain that information, and then the company would take that information, provide it to the registered agent, and then the anytime it changes within 14 days of that change, the company then would provide that information to the registered agent. What that does is then say the obligation and the requirement that information is always accurate and up to date is appropriate, not from a risk perspective, because if you think about it, now we disagree somewhat with certain issues, but if you think about it, if you tell me that the agent's responsibility is to update lower risk entities every 4 years, would you say that entity that has not been updated in 3 years, 11 months, that you have accurate and up-to-date beneficial ownership information? That might be questionable. So the way it works, it would work going forward is that the company, once it makes that change, would then be required to give that information to the registered agent, thereby all the information at all points would be accurate and up to date. It's a real technical distinction. We believe as a jurisdiction, currently we do have accurate and up to date beneficial ownership information. We have statistics to demonstrate we're able to provide that, but that's the effectiveness argument. But on the technical side, we have to make sure that legally the requirement is there. So when we get to the effectiveness of giving them statistics of where we're able for international cooperation perspective to provide beneficial ownership information, that is then a different discussion that we would have.
Okay. You said you have 14 or 13 pieces of legislation that needs 11. To be passed. 11? Okay, and we're hoping that they will get through the House tomorrow.
Yes, that is the expectation. That is the commitment of the present government to have committed their importance to the assessment, and that this would get done tomorrow.
Okay, we have some more questions coming through. With what level of confidence do we go into the assessment with respect to our effectiveness as a jurisdiction in implementing our legal framework?
As an assessor, again, I started going to this assessment in a neutral way. There is a lot that we have done to demonstrate effectiveness. We are putting the processes in place so we have the relevant information to demonstrate to the assessment team we are effective in various areas. I would be wrong to say that there aren't areas that we need improvement. We know there are areas we need improvement, but we have developed information which we are putting towards the assessment team to demonstrate effectiveness at certain levels, higher in certain areas than others. But as I say, I go into it as a neutral person, knowing how assessments work, but yet still be confident enough that we have put a lot in place in our jurisdiction to demonstrate effectiveness.
Okay. Is there a specific format by which a company should update the registered agent on its beneficial ownership? And can this be done by email?
There is no designated format. And I think this can be done by whatever means have agreed between the company and the agent. I think at the end of the day, we all has to remember that the company is your client already. So whatever you agree and whatever systems you put in place for the company to provide that information, my view is that system should be similar to your existing system for your KYC information. However, you currently receive beneficial ownership, you should implement it in that regard. And it should, in my view, it should be as efficient as how you have it currently.
Okay. When will the report on the results of the assessment be available? What is the process of the assessment? I mean, you said it started before. We're going to have the assessors on the ground for a 3-week period or so, and then it's going to continue to be completed, I think, after they leave the jurisdiction. So what is the process? How long will it take?
Okay, so I could start with the end game. The final report is scheduled to be heard at the November 2023 CFATF plenary. That plenary is likely to be in Aruba. So now coming to the present, the team is going to be on the ground till the 31st. At the end of the on-site, there's going to be what you call a closeout meeting. In that closeout meeting, they'll give you a general idea of the findings. Wouldn't tell you exactly ratings or anything, but general idea of the findings. So you'll have an idea of what they found. 2 months from the date of when they leave here, they have to produce what you call a first draft report. That first draft report is shared with the jurisdiction for the jurisdiction to provide its comments on any factual issues, any misinterpretation, any issues the assessment team may have missed, any concerns it's raised. So you have that to provide to the assessment team. And between then and the November, there are going to be several meetings, several iterations. There's going to be what they call a second draft. That second draft is effectively a draft that goes out to what they call reviewers and other persons to take a look at, and including the jurisdiction could be providing comments up to that point. There's going to be what you call a face-to-face meeting. In between that point, that face-to-face meeting is where the assessment team and the jurisdiction sits down and tries to hash out any remaining issues. Usually maybe there's 2 or 3 or 3 or 4 remaining issues that need to hash out and can be done through emails and the like, and the virtual meeting. So you have what you call a face-to-face meeting. After that face-to-face meeting, a report is produced that goes to what they call a global network and to all CFATF members for comments for the November plenary. That report then cannot be changed again unless that change is made at plenary. So that document is effectively sort of sealed. Yes, you would still have discussions between the country and the assessment team, but no change can be made to the document. All those changes would have to be made at plenary. At plenary, you have 2 attempts of it at agreeing the report and 2 attempts of potential changes. So you have what you call a working group, which will deal with all of the issues surrounding what has come up and what the assessment team have, what the jurisdiction have, and they will come up with what they call key issues. It's usually a key issues table, and those will be discussed at the working group. The working group now will make a decision on what issues would go to plenary. Again, the working group will make recommendations for changes. It can make recommendations for upgrade to recommendations, can make recommendations for downgrade to recommendations, but it doesn't make the decision. The decisions are then made at plenary. So the working group would then produce a document for plenary, which would be called a key issues table discussion for plenary. It is usually no more than 2 or 3 issues. In fact, I think the methodology says the maximum is 3 issues to be discussed at plenary, because you usually have resolved all the issues that you can before then. It is not up to the jurisdiction to say an issue should go to plenary. It's up to the working group. At each one of these meetings, there are set timelines. I think in the working group, you have 4 hours to discuss it. And plenary, I think it's 3, might be 2. So you have a limited time. If when you resolve all of the key issues and there's additional time, the jurisdiction can raise additional issues. If not, that's it, you can't raise additional issues. So then the report is then agreed at plenary. So CFATF agrees the report, but there's a additional stage yet to come, which is The final report then goes out to what they call quality and consistency review of the global network. The global network comprises of the FATF and all FSRBs, which is these FATF regional style bodies, which CFATF is a member. So they would have the opportunity to look at the report. They have a month, I think, to look at the report. If any two jurisdictions raise the same issue of consistency in the report then would go directly to FATF plenary for consideration of whether those issues need to then be opened back in the report. FATF can and has in the past made determination that issues are relevant and inconsistencies have occurred in reports, and they have literally made the change themselves. As recently, I think, as Venezuela last in February was downgraded in recommendation 15 from largely compliant, which was agreed at CFATF, to partially compliant, which FATF made the determination that it should be. And I know we had issues in relation to the Cayman report as well, surrounding similar things. So at the end of the day, FATF sort of have a final pen. It is very rarely used, but it can be used when those issues are discussed. So at the end of the day, we expect that this report will likely be published sometime officially in either February or March 2024.
Is any of the drafts going to be shared at any point? Would they be public, or they're just?
No, drafts are confined to the first draft is confined to the jurisdiction and relevant people within. The second draft is a bit more wider draft. The third draft, which is the official draft for plenary, is circulated to all of the global network. Under the process and what all of us signed up to, those documents are confidential and private and cannot be shared with any private sector individuals or entities. It can be shared internally as a jurisdiction with your public sector agencies. For example, all documents can be shared between the FSC, the FIA, but it can't be shared between the FSC and one of its licensees or anybody else in the public. That would be breaching the requirements. And I could tell you they take that very seriously, and they have actually instigated investigation in the past where that has happened in some jurisdiction, and it created significant issues. And we wouldn't want to be caught in that at all.
Okay, so I guess to answer your question, BVI Finance and the industry will not be seeing any of the drafts of the report.
Unless you classify yourself as public sector, and I have yet to see that.
Okay. You mentioned the different, ratings. I think it's so. Perhaps can you go through what are the ratings that we can possibly get in this assessment?
Okay, so I'll go to the technical compliance rating, and Glenford will do the effectiveness compliance rating. So there are 4 ratings where you could be non-compliant, meaning that you have severe deficiencies or weaknesses in that area. You can be partially compliant, meaning it's less than satisfactory. You can have a largely compliant rating, meaning that you have most of the requirements in place with minor deficiencies, or that you can be compliant, meaning that you have fully satisfied all the requirements of the recommendations.
Yes, and when you're speaking about effectiveness, there are 4 levels as well. You have the low level of effectiveness, which sort of says you have fundamental deficiencies and you need fundamental improvements. Then you have the moderate level, which says major improvements are necessary. Then you have the good ratings, which are substantial level, which says moderate improvements are needed. It's interesting that moderate don't say moderate, but substantial says moderate improvement. And then you have high level of effectiveness, which says minor improvements are needed and the immediate outcome is achieved to a large extent. In the methodology, it sets out under each immediate outcome, things that you need to cover, factors that they consider data that would help you to demonstrate compliance. So those are things that we took into consideration when we were providing what we call an immediate outcome submission to the assessment team, demonstrating what we think is our level of effectiveness.
Okay, we currently, I think we are largely compliant. Our overall assessment from the 2008 assessment, right? Unlike, is it similar to the OECD rating where if you get, I guess, more than a certain number of in one category, then you automatically go in a certain category? How is it done? I think you said there are 4 levels, but is it similar to the OECD process?
Yes and no. The way it works is, again, it's getting into the weeds of the technical nature of this. After the report is heard, you have what they call a post-observation period. This is a 1-year period from the date the report is published to 1 calendar year forward. Where it is, there is what they call FATF ICRG, International Cooperation Review Group. You could read, I mean, in all language, this is either blacklisting or not. I'll be frank with what that means. You don't want to get into the ICRG review group. To get into the ICRG review group, there's several criteria that you can get in. You can get in there on technical compliance. You can get in there on effectiveness. So you can get in there on a combination of both. There's various 3 or 4 ways how you can get in there, but ultimately you don't want to get in there. Once you meet the criteria, then what happens is you, within this quote unquote post-observation period. Within that post-observation period, after the end of 1 year, you then have to provide a report to FATF ICRG committee, which is for the Americas is called the FATF ICRG of the Americas, this region. They will do an assessment of whether you've made sufficient progress in order to not be taken up for what they call deficiencies and for review to ensure that you're becoming compliant and to develop an action plan, etc. And you would see similar to the process that Cayman Islands is currently going through and the difficulty with getting off that list. So that's the process that you go through at the end of the day. And I must say that there's other criteria in relation to how do you get the sort of put you in an ICRG pool. How do you get taken out of that pool? It has a definition about money. It has a definition about whether you pose a particular risk to the global network. The BVI is likely not to meet the money criteria because we don't issue currencies and stuff. But I could tell you, any one of us would tell you the criteria where it talks about the risk to the global network. As a significant IFC, we would meet that criteria. And as well, there's also other criteria where you can be nominated. And I think that happened to Venezuela, was actually nominated by a number of jurisdictions. But that's just a criteria. I'm not saying that falls and that would happen to the BVI. But yes, there is the ICRG process that can come after the assessment.
Okay, we have a couple questions. Given that our assessment period is now 6 years post 2017, with much occurring since that period, how are the assessors determining what period should be examined? And will it be fair, given that our jurisdiction may have been assessed previously by their plan date?
Yeah, I think that the review period is technically 2018 to 2022. That's a review period. It usually goes back 4 to 5 years. So we use that period of review and then look across the board to see what you have been doing over that period, where you started, where you end up. They look at various issues. I tend not to try to use the word fair because the process is the process. And they will take into consideration certain issues. We all know the issues around the COVID and what transpired and how that might have impacted things like doing inspections and those type of things. But we are in the process and you know, we'll figure out how the assessment team takes that into consideration. But I also say we have done, as a jurisdiction, we have done a lot since 2018. We have put a lot in place. There has been a lot of resources put to make us better place than we were before. As Mr. Baker said, I think we are in a better place now than we were in 2017, but also the methodology and the recommendations have come a bit more difficult than they were in 2017 as well. So it's kind of like you're damned if you do, you're damned if you don't type of thing, because everything has moved on, and you know, the global economy, the global nature of things has changed a bit over that period of time.
And also we've had some issues that came about that may not have necessarily been brought to the attention had it not been 2022. We have another question, and that segues from what you just said in terms of the tremendous amount of work that you have been doing since 2018. And based on the work that the Commission and all its agencies have done to date, what are the contingencies in place for the assessment, if the assessment report reveals a result that is not in line with your expectations?
Again, we have an idea of what needs to be done if it's not in line with what our expectations are. And we have an idea that what needs to be done and who needs to do what, but we're not at that point right now. And I think the thing about these type of assessment is the jurisdiction needs to be careful not to sort of say we're gonna get to that point. The key is to demonstrate that you're at a point where you're effective and put all of your energy into demonstrating that you're effective. We know we're gonna have some gaps. That is clear. We know we're gonna have some gaps. Every jurisdiction have gaps, but we have to demonstrate where we making changes to those gaps, those things that are being set out, things that we are doing appropriately. So our goal is to demonstrate as best as possible effectiveness. And once the assessment teams and the report comes to that point, then we will make a plan as to how to address any issues in that report.
You mentioned, you know, some of the other jurisdictions that have recently had not so favorable ratings, and I'm sure that you've been looking very closely at what some of the gaps that were identified in their reports. I think some things are dissimilar to us in terms of like the banking sector you mentioned from Cayman Islands, et cetera. But what are some of the gaps that you would have identified in other jurisdictions that may be, you know, similar to ours, and what have we done to correct those gaps that we've identified?
Well, we've been looking at, as you rightfully said, other reports and similar and on similar jurisdiction from us to see what gaps need to be filled, and we've been filling a number of those gaps. I don't want to say particular what they are, but a lot of them revolve around legislation, how do we supervise, revolve around risk assessment, etc. But we have to be frank about ourselves. The BVI is unique. It is not much jurisdiction that have 350,000 corporate entities. That's the uniqueness of the BVI, and that is going to be where the assessment team is going to concentrate on how are we managing whatever risk emanates from that sector. I don't think, even if you look at, for example, Cayman Islands, and I think they have, at the time of their assessment, they had like, I think 90-something thousand companies, but at least 80,000 of them, I believe, were in the mutual fund sector or that type of sector. So the risk was different. So you can't then look at that and say, this is how they're going to address the BVI risk. But we looked at it to say, okay, you've looked at certain things. We're going to make sure our house is in order on these levels as well. So we do a lot of look around. We look at a lot of the bigger jurisdiction. I know up to this week, I was looking at the German report for particular information on how they address recommendation 40. So it is, every jurisdiction has something to offer from their assessment.
And I take it you also had a mock assessment or mock evaluation. How was that? What was the result?
You never have results on the mock. What you have is feedback. So we did mock interviews from, we engaged with His Majesty's Treasury in the UK through the governor's office and approval from NAMLAC to engage in that, and they provided substantial feedback to us where we were going right, where they think we could add additional information, which was helpful to us. Again, all of that is part of the process. You know you're going to be interviewed, so you go and you get you figure out, okay, let me test what my responses would be and get feedback from an independent third party, not from yourself. So those were extremely helpful.
Okay, we have a question that, given some of the legislation will be passed in the House tomorrow, how will you demonstrate, or how will we demonstrate effectiveness if legislation is just being passed?
Again, we think a significant amount of these legislation is just codifying what we already do. We would make the arguments to the assessment team as to why that is the case. Some of the legislation are things that we literally disagree with. For example, I'll give you one case. There's a requirement under the recommendation for competent authorities to provide feedback when requested. All competent authorities does that, but the fact is that what the assessment team is looking for is a specific section in the law that gives you the power to provide feedback. I mean, come on, we don't think that's a material issue, but we're making sure we're technically compliant and we're changing the law to make that happen. But the question is valid. There's some parts of it that we're not going to get effectiveness for in terms of technical compliance, where it is totally something absolutely new and we can't make the argument for. But most of it, in our eyes, we think we can make an argument for.
Okay, you said you've selected a pool of people who will be interviewed, and you have been going through a sensitization process with them. Can the assessors go outside of that selected pool and interview people outside of that pool, or select people that they want to interview themselves? Or are they confined to just using the people that you provide for interviews?
They're confined to agree with us who to interview. What the assessment team says, for example, let's use trust and company service providers, for example. What the assessment team would say, okay, we want to see some large ones, some medium-sized ones, and some small ones. So they'll set out the criteria as what they want to see, and we provide them with those persons. So if they're looking at the TCSP sector and they say, okay, well, I got a kind of funny remark from a smaller TCSP, could you, we want to interview another smaller TCSP, then is when we would go to the pool, but not that they would go trolling somewhere on a website and then pick who they want to interview. No, that is not acceptable, and that is not how the process works, and that is not how the process has worked up to this point. But I should also say, though, if, knock on wood, during the middle of the assessment, something happens to a particular financial institution, the assessment team would be well within their right to say, well, we probably need to speak to these people to figure out what is actually, whether they have proper internal controls and as well. So issues might crop up, which is pretty rare, but it may.
How much of what's in the news do they take into consideration?
A lot. They take it in terms of risk and context, and we're then having to provide information which demonstrate that we have effective systems. The assessment team does research, just like anyone who's doing an audit. I could, as I said to a lot of the, as I said to the sensitization grouping, the assessment team has already gone on every person's website who they are to be interviewed. And if you have something on your website that is not right, they may ask you a question. For example, and I use this term, in the BVI, there is no concept, and I repeat again, there is no concept of a nominee director. But the assessment team, and I'll be frank, have gone on a number of TCSP's website who are offering nominee director services. That does not exist in the BVI. Under the BVI law, director is a director is a director. But yet still on people's website, they're offering the service of nominee directorship. So that is an issue we now having to deal with the assessment team, because it's not legally allowed in the BVI, but the assessment team has already done their research. And again, this is something that people would be raising when probably they meet. I've already said that to the sensitization folks as well. So again, these are the things that we all do when we are an assessor. We go and we do our research and we come with the questions.
Okay. What kind of questions were directed to the selected organizations during the sensitization process?
Well, what we did is we set out what we think areas the assessment team will look at, some of the questions. We did a presentation. I do apologize. I think we are supposed to send that presentation to all of those entities so they could have that officially. I'll have that done by the end of the week so they could, have an idea of what it is officially on the presentation. But again, this is really straightforward stuff. You are TCSP, you are bank, you know what you do. They just come in to ask you, how you do CDD, how do you carry out enhanced due diligence? How do you monitor your clients? The filing of SARS, you know what you do. And as we said to the folks, walk with your compliance officer, MLRO. It is no sense just the CEO showing up and start talking about business. They don't want to hear anything about business. They want to hear how you undertake these responsibilities.
So will the assessors be based at the commission or will they be going out in the field to the various offices?
They're based, the facilities they're using are those are the commission. I don't want to say the base at the commission, because technically they're not. They're just using the commission's facilities, and everyone is coming here to interview. Under the process, there's a few agencies I think they have to visit. For example, they must go to the physical premise of the FIU to ensure that it is properly secured as the recommendation requires, but they're not going to financial institutions.
Okay, they're going to the ports and the airport?
Well, they're coming in at the airport. No, I think it's just the FIA that they're going to.
Okay. I take it for granted if you have not been contacted by the commission, you're not a part of the pool that's going to be interviewed. Is that correct?
That is correct.
How large is the pool?
It's a good question. I think in relation to I think there are 4 banks, there are about 90 CSPs, there I think 2 insurers, 2 investment, 1 money service, 1 financing. There are about the same amount of DNFBPs and I think 2 NPOs who are selected to be interviewed, as well as a pool of similar amount. So it's probably, I would say, somewhere in the range about maybe 40 or no more than that, about 60 firms in total.
Okay. So
And again, like I said, this includes DNFVPs and MPOs, which FIA is the supervisor of.
is there any particular, based on, your meetings with them so far, is there anything that you want to stress?
But I think I stressed it before. Those people who have been interviewed just needs to say what they're doing. I think this is not rocket science. I think if we selected you, we've done our assessment that you're capable of saying what you need to say. So most of the people just need to, bring the compliance officer, bring the MLRO, answer the question. If you're unable to answer the question, just defer the question. And I think the assessment team, from my experience and my understanding from other people, are not people who would be aggressively interrogating anyone. That is not their purpose. If that is happening, then persons need to just reach out to us after the interview. But we have never seen that to be the case. They're just asking you what you do and provide documentation. When I said documentation, I think one of the few documents that I've seen in my dealings that they've asked for is your client take-on application form, not your procedure necessarily, but your application form, maybe various application forms that are blank, not client's documentation.
Okay. So I think based on what you've said so far, there's going to be almost a year before we actually see the final report.
It's going to be almost a year before the actual report is final. We would see it a long way before that, but yes.
Okay, I meant the public.
Yes.
Yes. If there are any final questions, please, I think I see one more question. Is it possible to know out of the 9 TSCPs selected in the pool, how many are large, how many medium, and how many are small?
In my view, there are probably about three significantly large ones, about 4 in between, and I think 2 small ones.
Okay. All right, I think it's now 13 past the hour, so I will ask Mr. Baker if there's any final words that he has to say in terms of this assessment. They've said a lot in terms of this whole process and what has gone on to get us to this point. We are reminding the industry that the assessors will be in the BVI from the 13th to the 31st. And the assessment, as he said, starts on the 15th of March. And that's next week. So we want to make sure that we are doing all that we are required to do to make sure that the BVI comes out with a good compliance rating in this assessment. I know a lot of work has been done to get us to this point. And we want to thank the Commission for all that they've been doing for these last couple of years, and including getting the legislation to the House tomorrow. And we will pray that all goes well in that regard. I will now ask Mr. Baker and Mr. Malone to close out.
I'll let Mr. Baker go last, but just let me say one thing. Assessment team, it is not unheard of for assessment team to actually attempt transactions while on island. So they might go into a money service and try to send money. They might go into a bank and try to do something. I've never heard them try to open a company, but I don't know whether they would attempt to do those type of things. So it's not unheard of. And I also want to say at the end of it, yes, the Commission is leading, but there's a lot of other agencies that are significantly involved, which I mentioned earlier. So whilst we play a kind of centralized role, there's a lot of agencies that are involved.
If I could follow up on something Mr. Malone said, at least in that, whilst the interviews will be conducted here and the commission's premises, they're going to be here for a couple of weeks, and so they will also interact with other persons, whether at a hotel, restaurants, or other places that they may go. Because I recall in 2004, I did an assessment of a jurisdiction, and when I got to the hotel and sat to the bar to have a soda, the bartender started talking about how that jurisdiction is such a big money laundering center and so forth. And they didn't know, the person, sitting in front of them was an assessment, financial sector assessor. So that is something, the listening audience also need to be mindful of. They will be, up and about, certainly in the afternoon hours. I will interact with other persons, and they need to be mindful, that, could be sometimes, say things off the cuff, but you need to be mindful of that they will be interacting with other persons in the normal course of events.
I think that's very important based on some of the comments we often hear thrown about throughout the jurisdiction. So,
and sometimes we see them written in the online blogs as well.
Yes. So we need to make sure there are not a lot of loose lips running around the place during that period. But if they are loose lips, that they are saying positive things about the jurisdiction.
That's good.
I think somebody put a last minute question. Let me see what this is. We have serious concerns about the new AML's KYC obligations on companies, the change on BC Act, which will treat them as if they are regulated persons with full KYC obligations in relation to their 10% UBOs. This change is unnecessary and extremely burdensome, given, okay, I think, Matthew, we're going to wrap up. So we are going to get this question directed and answered to you directly. He's asking about the change, which is
let me address it. I think it's important. Let me address it quickly, because the change does not put an AML CFT obligation on the company. It puts a BC Act obligation on a company to have that information. So the company itself is not necessarily going out and collecting CDD and all that information on the beneficial owner. That remains with the agent. Let's be frank. And again, if you look at recommendation 24 and see what the specific requirements are, you have absolutely no choice.
He's saying again, let me fully give the question since you're answering it. This change is unnecessary and extremely burdensome given the existing BOSS regime, which places obligations on companies to identify and provide the prescribed information on their 25% ultimate beneficial owners. Why is the change considered necessary?
That question is a lot longer than it says, but I would just say that BOSS and have its own significant issues. That is why it is not specifically useful for AML CFT compliance with the FATF recommendation, because there's a significant amount of holes in there in terms of verification, etc. And again, the submission in BOSS is by the agent, not the company, and the company doesn't have a requirement to maintain. The requirement to maintain under the provisions of FATF is that the company has to do it. If the company doesn't do it, you're non-compliant. There isn't no in-between answer to that. And again, it's just a matter of maintaining that information. So it's a bit different than BOSS.
So I think what you're saying, the onus of responsibility is on the company and not the registered agent. So that is the thing that differentiates this new AML requirement versus the BOSS requirements. Is that correct?
There's a lot of differentiation, but I just want to make it clear that there's some difference there. And again, probably for our next breakfast discussion in more detail. But yes.
Okay. And I think you will get some more details on that, back to Matthew. So I think, Mr. Baker, you were finishing up.
Yes, I was finishing up to say that they will interact with other persons, but let me just finish up by saying certainly thanks for the opportunity to share what has been going on in the preparation for this upcoming mutual evaluation. And I will certainly look forward to engaging with BVI Finance for another breakfast forum. Just yesterday, we had some meeting and topic came up that we think would be suitable for a breakfast forum on VAS, the legislative framework. So we'll be reaching out to you to address that. And Mr. Malone also mentioned that we should probably discuss this beneficial ownership thing in more detail. So again, I think there's a lot for us to be able to discuss, in future breakfast forums.
Yes, and we will be going to the public in the next couple of days. We'll be on, I guess, the various media, whether online or on the radio, trying to get the message out that yes, please, no loose lips in the bars or in the restaurants or on the street, because you never know. You may be talking to one of the 10 assessors that are here from the IMF or the CFATF. I really want to thank Mr. Malone and Mr. Baker for taking the time to explain to us about the CFATF, the 4th round mutual evaluation, and what it means for the jurisdiction, and all the roles that we all have to play in terms of getting through this assessment and getting us for a favorable when the report comes or the draft comes to the commission. I thank you also for coming out and being in attendance at this breakfast forum. I am Elise Donovan for BVI Finance, and I just wanted to say, going back to the first question, I think we'll be having an announcement from government tomorrow with regard to the OECD supplementary review application. It's some positive news, and so the government will be making that announcement, I think, tomorrow or shortly. So look out for that as well. And thank you very much for joining us, and do have a pleasant day. This has been a BVI Finance Breakfast Forum.